With that, we will then call our second case. State of Kansas versus Sidney Clark. Ms. Miller, you may begin.
Did you want appearances?
Yes, at the podium.
May it please the court, Mr. Clark is in custody and appears by counsel Wendy Miller.
You could enter your appearance when you go to the podium.
Well, we're here from another appeal.
Oh, I'm going to stop you. Rebuttal time, Ms. Miller?
Yes, please, 2 minutes.
2 minutes, thank you.
So this is an appeal from the second resentencing for Mr. Clark. One of the issues that he raises in his brief is that he had filed a motion prior to resentencing back in 2022, which was the most recent resentencing, challenging his prior convictions. And he made a general challenge to his convictions. And then he also indicated that some of the convictions may be uncounseled, and asked basically that for the state to hold their burden and prove his prior convictions, noting that there was no documentation to support the convictions included with the PSI, such as journal entries or other documentation to support the convictions.
Now, counsel, am I correct that by the time this motion was filed, your client had already admitted the accuracy of the PSI twice?
In his prior proceedings, he did, but because this was resentencing, then, and he can't agree to an illegal sentence, he could come back and challenge his criminal history since he was being resentenced. So with his written objection to the criminal history.
Can I stop you there? I'm
Yes.
intrigued by a phrase you used. You said he made a general challenge to his convictions. What do you mean by general challenge? I'm not used to that. If I was a district court judge and someone says I'm generally challenging my criminal history, can you explain what that means in order for the...
My understanding is that he was challenging all of his convictions that were listed in the PSI.
Under what basis?
Well, he indicated that some of them may be uncounseled and asked for the court to hold the state to their burden to prove those convictions. And the other basis would be because he didn't believe they were supported with any kind of documentation, such as journal entries or other kind of documentation.
Now, counsel, normally when we have challenges to a criminal history, we've got a burden shifting framework, correct?
Yes.
Where, depending on where we are in the stage of the proceedings, when the challenge is raised, that really dictates who has the burden. So here we've got a situation where your client admitted twice to the accuracy of the PSI, and then several years later is trying to shift the burden onto the state. Why shouldn't we take that into account and say, at this point in the proceedings, after you've already admitted it twice and all this time has gone past, that you, Clark, have the burden to show that the PSI is inaccurate and have a very specific challenge, like maybe point out which conviction wasn't counseled, or give some specifics, or provide the documentation to show that a conviction was misclassified. Why should we, at that late stage, under those circumstances, then force the state to prove and bring the documents for all of those convictions?
I'm not sure that it necessarily matters that he didn't challenge it previously or previously on appeal, because once the court remanded for resentencing, and vacated his sentence, he had to be sentenced anew. So in doing that, the district court would have to consider his criminal history.
But wasn't the remand a little more limited? I mean, didn't the remand basically say go back to that first sentence?
It did say to go back to the first sentence, but in doing that, I think that as part of resentencing him, that the criminal history can't be ignored. So if he makes the written objection, the state then has the burden to prove the criminal history.
And I'm not suggesting it should be ignored. I'm just talking about the burden shifting. Why isn't it Clark's responsibility to prove the inaccuracy at that point?
So we cited a case in our brief that the state can't rely on a PSI when an objection has been filed. That places the burden on the state to provide further evidence. And I think that was the Show opinion, 287 Kansas 529.
Is that a similar context that we have here? I mean, doesn't that case talk about the initial challenge? I mean, like the first time it comes up?
Right, and this is not the first time he's been sentenced, but this is sentencing anew. So it's a full resentencing. He's not just coming down for, for example, to correct a post-release provision, or maybe the case where the judge misstates that someone should be on lifetime post-release instead of stating parole, and it's just correcting that part of the sentence. In this case, the sentence was vacated and remanded for resentencing, and it was consistent with their opinion, because the continuing challenge has always been whether to apply Wettrick or not, and the developments that have come into play since Wettrick. So, but I think once the sentence has been vacated and remanded, then sentencing anew has to take place, and in doing so, if he files a written objection to that criminal history, pursuant to, or in this resentencing, then that shifts the burden to the state to respond to it, even if he didn't do it previously, because this is sentencing anew.
You said pursuant to, were you about to give us a statute?
I did cite a statute, 216813B5, which requires the source of information behind the conviction. So there's got to be journal entries or other documents. Mr. Clark's opinion argument is that because the PSI lacks information about how those convictions were verified, and it doesn't contain any journal entries, that was his objection to including the priors, and so that he should be resentenced at an I. And then, as we've indicated in our reply brief, if we look at Dickey, which said that a stipulation or lack of objection regarding how convictions should be classified or counted as a matter of law for the purpose of determining criminal history, that will not prevent a subsequent challenge under the illegal sentence statute 223504. In this case, we're not dealing with a motion to correct an illegal sentence. We're dealing with a motion, or with resentencing, and so
Wait,
it's our
aren't you
position.
dealing with the motion to correct a legal sentence? It
Well,
was
that's how it started. But the remedy for, or I guess the finding of the court, was that the sentence in 2019 was illegal, and so that sentence was, on appeal, was vacated and remanded for sentencing anew. So our position is that the court cannot sentence him without considering that criminal history. And even if he didn't raise it in a previous sentencing, because it's sentencing anew, if he files the written objection, then the state has got the burden to prove that conviction.
I'm going to quote you the last sentence of that State v. Clark, and I'm going to get very detailed, so bear with me. Based on the foregoing analysis, we affirm the judgment of the Court of Appeals, reverse the judgment of the District Court, vacate Clark's 2019 sentence, and remand for resentencing consistent with this opinion. All right, so consistent with this opinion, does that tell the District Court to sentence him as a criminal history score B? Because consistent with this opinion means something. It has to mean something.
I think the court, in carrying out his duties and sentencing him consistent with the opinion that if something arises, that the district court has to address in order to proceed with the mandate and what the mandate's directing him to do, that can be taken up and should be taken up. So I don't think it would be inconsistent with the opinion if he had additional written objections concerning the convictions to take that matter up, if that answers the question.
What did you mean by that?
So he was to be resentenced consistent with the opinion, and so the opinion was dealing with the Wettrick objection or the Wettrick line of cases and how the history should be scored, whether the Oklahoma conviction
Right.
should be scored as a person felony. But once the sentence is vacated and remanded for full resentencing, I think the additional written objection by Mr. Clark can and should be taken up by the court in executing his duties to follow the court's mandate.
Okay.
And I believe, I base that off of the decision in Soto, where if a new matter arises, new situations that the court needs to take up in following the mandate, such as somewhat similar as the facts in Soto, where there was new factual evidence that was presented in a motion for a new trial. And so the question was, could that be taken up? Would that be consistent with the mandate? And the court found that in executing his duties, that was something that the court could take up.
Do we have that same situation here?
I think that we do, in the sense that in resentencing Mr. Clark, that the court can't ignore the written objection. Once that's filed, this state has the burden to produce the evidence, and I don't think it's inconsistent with sentencing him in accord with the opinion. Now, there's nothing that's going to change about the Oklahoma conviction in that what they found about the elements. Okay, whether Wettrick applies or Vandervoort applies, that's been decided, and that's part of the mandate to resentence him. Is here's our decision, that was illegal in 2019. Now we go back for resentencing. But if he's got new written objections, I think the district court has to answer that.
Well, Soto, was it new written objections, or it was new information that came to light?
His was new factual evidence, and so he had filed a motion for a new trial, and he was there for resentencing. And then there was a question with whether the motion for a new trial could be considered if it was outside of the mandate. So, but here I don't think it is. I think it is something that the district court needs to do if there's a written objection for any reason, because it is sentencing anew. So if criminal history is, the court has to decide that in sentencing him. And that's not inconsistent with what the court's decision was regarding the Wettrick argument.
If a defendant makes a objection to their criminal history prior to sentence, must the district court always take it up?
I think it shifts the burden to this.
I mean, can't they look at the basis, can't they see if it's merit, if it's full of merit, if it's merit or has no merit to the arguments presented? Because from your argument, a district court would always have to take up a defendant's challenge to their criminal history.
I think if there's a written objection, then it's up to the state to prove the criminal history. And I can see I'm out of time.
Did you want to summarize your argument, or if you have wanted to?
Well, I didn't
If
get
you
very
don't
far
want to,
down the
I'm just
line
giving
with-
you, I'm just giving
with
you that
the-
out.
With the issues, but it's our position, at least on the criminal history, that the state didn't meet their burden, that the criminal history arguments should have been considered by the court, and that without having proof of the convictions being counseled, his case should be remanded and he should be resentenced with a criminal history score of I.
Thank you, Ms. Miller.
Thank you.
Go ahead and begin, Your Honor.
Yes?
Good
And-
morning, Your Honors. May it please the court, my name is Bach Hang. I'm an assistant district attorney with the Reno County District Attorney's Office on behalf of the Appalachian State of Kansas. Your Honors, I wanted to open up my oral argument by saying that this was not we're here now not because a panel of Your Honors on the Court of Appeals made a decision that the appellant, Mr. Clark, is trying to undo or overturn. It was the highest court here in our state, Kansas Supreme Court. The state's position is that the Kansas Supreme Court got it right. Their opinion is correct. Even after all of the back and forth arguments, even after twice Mr. Clark's journey to the Court of Appeals and then back to the district court and then back again, even through all that, as of today, as we sit here today, as we stand here today, there are principles about this issue that are tried and true. And make no mistake, this is about an illegal sentence or an illegal sentence claim by Mr. Clark. It drives the appellate issues in this case. 223504 is the statute that we're talking about. So those principles are that the law at the time of the sentence controls, the lens for what the court should have looked through in 2005, that lens was the comparable felony lens for the out-of-state conviction from Oklahoma. Placing bodily fluids was the name of the statute from Oklahoma. It is comparable to battery on a law enforcement officer. The Kansas Supreme Court's ruling is consistent also with its own rulings in Murdoch and in Wettrich. And I don't know if Your Honors have taken a look at the legislative history of 223504. Truth be told, I kind of geek out about legislative history. I love looking at session laws. I think it started right after I entered into private practice. But if you look at 223504, kind of surprised me, but only twice has the legislature changed that statute. And by change, I mean either added to it or amended it. On June 22nd, 2017, 223504, and that's the statute about correcting a legal sentence. It defined what an illegal sentence was, very narrowly defined. Constitutional challenges cannot be made. And then again, on May 23rd, 2019, the state legislature changed or amended 223504, and I think that was in response. A second here. That was in response to what the Kansas Supreme Court said in Murdoch. And that change basically was, it defined what change in the law was.
And counsel, is it Haig?
Hang, yes.
Haig, Mr. Haig, Ms. Miller is not disagreeing with you. Her argument is, he came back, he was supposed to be resentenced, at his sentencing, he moved to have the state prove his convictions add up to a criminal history score B. So what is your response to that? If I
Your
may
Honor, my
move you
response-
off
I'm
your
sorry.
legislative history review.
Your Honor, my response to that is, well, first of all, I don't know what appellant's counsel means by sentencing anew. I would echo and reiterate, Judge Pickering, your question and your, I don't know if you intended to, with your question to say this, but the Supreme Court of Kansas said, we're sending it back to be resentenced consistent with this opinion. And as your honors know from your collective experience, when an appellate court, be it a panel of a court of appeals, be it the Supreme Court of Kansas, says, well, we're remanding this back to you, and says consistent with this opinion, it's not sentencing anew. I know we're lawyers and we're always tasked to ask that question, what does that mean? What does that mean? Sentencing anew cannot mean what was briefed in the appellant's brief. It cannot mean, let's start over. It cannot mean, let's relitigate this case. It cannot mean, let's relitigate issues. There's got to be some finality here. And I think the Supreme Court of Kansas certainly could have written, let's remand for sentencing, and then stop talking and writing. It did not do that. The Supreme Court of Kansas, like it always does, is at least to me, it's pretty clear on the instructions on what the remand is, consistent with this opinion. Consistent with this opinion means district court, do whatever you want to do, give Mr. Clark his sentencing again, but it's got to be consistent with our opinion. And our opinion, Supreme Court said, was his criminal history is B as in boy, and that his sentence should be 460 months.
So, just to put this in framework, this is a motion to correct a legal sentence based on one thing. The one thing is that he challenged his Oklahoma felony and said it should have been a non-person versus person. That's the only argument he raised in motion to correct a legal sentence, correct?
Your Honor, that is the state's position.
Right. So based on that, should he be allowed to go back and be sentenced and being able to raise everything when he's only challenged that one aspect of his criminal history in his motion to correct a legal sentence?
Absolutely not, Your Honor, because if Mr. Clark is allowed to challenge, thing 2, 3, 4 again, then he's going to want to challenge thing 57, thing 65, and come up with other things. Example, Your Honor, an example of that, I'm not just making that up. An example of that is in the appellant's brief, stuff about there was a delay in the mandate, there's mootness here going on, there's a double jeopardy claim. Your Honors, all that is centered around one thing. I don't like my sentence was illegal. Unfortunately for Mr. Clark, the Supreme Court of Kansas has spoken already. And if you look at the Supreme Court's opinion in Clark, it wasn't just like, hey, let's write 3 pages and then affirm. It was a very, very well thought out written opinion. It started with, for I think 7, 8 pages. The Supreme Court dissects, are we even allowed to hear this? Do we even have jurisdiction? Yes, we do. Supreme Court even took, the Supreme Court even criticized the state for not doing what it, for not filing a petition to the Supreme Court earlier. So it was critical of the state. It was critical of Mr. Clark, and I think that what the Supreme Court did with that opinion was it said that, look, here's what Wetridge says, here's what Murdoch says, and here's what the law of the land is. And Your Honors, it wasn't everything that was analyzed by the Supreme Court in its opinion was consistent with what the statute says. I want your honors to also, I want to point out to your honors that the appellant's counsel did not mention it in her oral argument. But as your honors know, there was, I believe, an addendum that was filed by the appellant. There was a Kansas Supreme Court opinion. I think it's unpublished. Well, I'm sorry, it's not unpublished. There's just no citation yet. State of Kansas versus McCrae. It sounds like, when you read that opinion, it sounds like the appellant is saying, hold up. Is the Supreme Court saying something different than what it said when it ruled against Mr. Clark? Your honors, I would ask that you not fall for that. I think the Supreme Court in McCrae said the same things that it said when it ruled against Mr. Clark. Nothing in McCrae helps Mr. Clark. The principles that the Supreme Court talks about in McCrae are still true, still law. The law at the time of sentence controls. The lens to look through for Mr. Clark is, was that out-of-state conviction comparable to a felony here in Kansas? And if you think about it, your honors, Mr. Clark waits 12 years, right? He waits 12 years to file a motion to correct legal sentence. And I think one way to look at that is he wasn't even talking about his sentence being legal.
Well, in his defense, Murdoch doesn't come out
And-
for many years.
And Judge Pickering,
I mean, because he's sentenced in '05, and none of this starts playing for another 10 years.
Judge Pickering, I'm glad you brought that up. I think that lots of prosecutors would look at that and say, come on, judges, he waited 12 years. Why did he wait so long? Here is the state's position here in this case. It wouldn't have mattered how long he waited. I mean, think about it. It wouldn't have mattered. If Mr. Clark, the opinion in McCrae, on the premise that McCrae, that the appellant is saying, hold up, McCrae is saying something different. Kansas Supreme Court, you're saying something different than what you said in Clark with McCrae. On that premise, here's the state's response to that. Because McCrae was decided, it looks like, December 25th. I think it was December of 2025, so like a month and a half ago. The state's position on that is, let's get into a time machine. Let's travel back in time. And let's have Mr. Clark make his initial motion to correct legal sentence. Because as your honors know, you can correct a legal sentence. A judge can certainly take it up at any time. Let's say he did it on January the 3rd of 2026, or he did it like yesterday. The state's position is it wouldn't have mattered. He certainly did not know about Murdoch and Wetridge, but we have the case law we have now. And so now what the state is saying is now the Kansas Supreme Court's ruling that it made in Clark, saying that your criminal history is B as in boy, your out-of-state conviction in Oklahoma is a personal felony, it remains intact even through all the Wetridge stuff, even through all the Murdoch stuff, even through Clark 1, Clark 2, even through all the analysis, even through all the changes by the legislature. It makes sense. Plus, the opinion makes sense, does it not, Your Honors? I mean, sometimes logic.
The court is really basically saying it should be a B in light of in Clark, the Supreme Court is recognizing case law has changed, and now it reverts back to a B, right?
Correct. And I would close my remarks with saying, sometimes logic and law don't always coexist Sometimes I think legislators, judges, prosecutors, defense lawyers, we say things, we write things that, you know, there's probably a legal principle that upholds it, but it doesn't make much sense. Your Honors, here in this case, the Supreme Court of Kansas made sense when they said, you know, when you get sentenced, at the time you get sentenced, that law should control. And that's the state's position. And thank you for the time, Your Honors.
Thank you.
If you have any more questions, I'm happy to answer.
No. All right, thank you. Ms. Miller, you have your rebuttal time?
Yes, just briefly. The court-
Can you just give us a second? We're fixing the clock to get
Sure.
you, so I could take a breather. All right, you may proceed, Ms. Miller.
I just wanted to, the court had asked if there was a statute under which Mr. Clark was requesting his criminal history. And so in our brief, we had cited 21-6814 C, and also 6814A. And in talking about, can the district court do anything else other than what the mandate is stating? As you're aware, Mr. Clark's counsel filed a motion for departure, and he had requested discovery. He had secured approval for an expert, so he wanted discovery for the expert to see, because he didn't know, you know, everything in the case. He was just getting acclimated with it, so he asked for a continuance, which was denied. He filed a basic departure motion that did have some good departure reasons in it. But our position is, in Dixon, in the case we cited in our brief, there was a question whether the court could take up the motion for departure at resentencing. And the court found that when an appellate court vacates a sentence, the mandate requires the court to sentence anew. So the defendant is in the same position as he was in the original sentence. So our position is, yes, he can file that motion for departure. And we believe that the district court should have granted that continuance so that defense counsel could have presented mitigating evidence on behalf of Mr. Clark in support of the motion for departure. And there are instances where that yes, you can, and that does not negate or somehow not follow the mandate. And I can see that I'm out of time, so unless there's any questions.
I really appreciate both parties' arguments. You may sit down. Thank you.
Thank you.
All right, we will take that matter under advisement.